I think that takes us pretty well to the oral arguments and how the justices reacted to these arguments that you and the ACLU and the NRA and others have put forward versus Vullo and her supporters. And even the DOJ the government had a little bit of a different take from you guys in some ways. And so I'm interested in your reaction to this. To me, I listened, and it honestly, it seems like now oral arguments, right? I'm sure you agree. You can't totally rely on what happens in oral arguments, and you'd be a bit foolish to make a 100% prediction. But sometimes, you can read the tea leaves, and in this case, it seemed pretty clear that most of the justices were sympathetic to the idea that the First Amendment had been violated here in some way. Whether what theory of it, maybe there was some disagreement there, but I'm interested in how you think overall the oral arguments went for your side.
Yeah, well, I try never to make predictions after oral argument, and I can tell you from experience, when you do an oral argument, every oral argument is 3 arguments. It's the argument you plan, the argument you give, and the argument you wished you'd given. And so all you can really tell coming out of an argument is basically, how did you feel? Did you feel it trended in your direction or not in your direction?
Yeah.
And those feelings can betray you because you can come out of an argument feeling really good and lose the case. Yeah, sure. You can feel coming out of an argument thinking you got the shit beat out of you, and in the end you prevail. I mean, so it really depends on a lot of different factors. And one of the factors that was important in this case is the idea that this was a double header. This was 2 arguments, both of them related to the issue of jawboning, or the issue of the use of government power to restrict speech. The first one, which you might say is the headliner, Murphy versus Missouri, had to do with the Biden administration's accusations that the Biden administration had been pressuring social media companies to change their moderation policies. And so
to remove like anti-vax posts and various other posts they didn't like.
And so the argument in NRA versus Vullo, while it raised the same basic First Amendment problem in a somewhat different context, followed an hour and a half of argument on this other issue that raised some even more complicated factors, given the relationship between government and social media companies. So it's hard to evaluate the argument presented in NRA versus Vullo, given the fact that it came on the heels of the first argument of the morning. And after an hour and a half of talking about this issue in the Murphy case, it could just be that everyone was pretty much exhausted. So the argument in NRA lasted only about 2/3 of the time that the argument did in Murphy versus Missouri. And if you follow the transcript, you'll see that some of the questions that the justice would ask would say, well, as in the first argument this morning, I was talking about this, and here's how the issue is presented here. So it's all a long windup, I understand, for getting to evaluating the argument. But I will say that I came out of the argument feeling pretty good for the position that we had advanced, thinking that the court really seemed to be disposed to understanding when government pressure went too far. The same question came up in this case as it had in the earlier one, and that is, how do you set the line on what is going too far? And that was part of what distinguished the NRA's position from the federal government's position. As you mentioned, the Solicitor General had filed a brief in support of the NRA, but only partially in support of the NRA, saying that certain activities appeared to go too far, while others did not. They were within, it believed, the lawful authority of government to speak from the bully pulpit and to advocate positions. I think when you look at our position, at least, was when you look at all of those actions taken together, and given how they were part of a uniform campaign, that it's really hard to separate them out, and that they were all examples that reinforced each other of the government trying to leverage its regulatory power for illegitimate ends.
Right. And I'll say that I thought that the NRA case went much better because you guys also filed a brief in support of the Murphy plaintiffs, I guess, in that case, right?
Well, they were the plaintiffs in the lower courts. They were the respondents in the Supreme Court because it was the government that was appealing.
Right.
And
but you in both cases, you take the position that the government went too far and violated the First Amendment. It did seem like, and maybe this is just, like you said, could just be exhaustion from arguing about the same basic concept for so long, but it felt like the justice could see a more straightforward path in this one.
Well,
perhaps
one of the things that made the NRA case perhaps more straightforward is because you had a less complicated record to go through.
Yeah.
I mean, in the NRA case, you had a couple of guidance letters, a meeting, you had a press release from the governor. You had a limited set of facts that really focused in on where the problem might be. Mm-hmm. That's not something you can say about the Murphy case, where you have a 20,000 page record. You have all kinds of contacts between various actors in the federal government and various internet platforms. And so parsing through all of that to find where the government had overstepped and by precisely how much and by what means is a much harder thing to identify. And many of the questions that came up in the first argument had to do with that complicated factual record. Right. And so it's, I think, easier to come away from the NRA argument having a more firm feel or a more firm conclusion on what the court might do as opposed to the first argument.
Yeah, especially because Vullo was pretty, and of the other New York officials you mentioned, the Governor Cuomo was pretty straightforward about why she didn't like the NRA.
There wasn't much ambiguity here.
She didn't like them because they're a gun promotion group, as she called them, and she talked about this in her letters about why people shouldn't work with them. And I mean,
exactly. And the governor saying that working with the NRA sends the wrong message. Well,
right.
If your justification as a member of government is that you want to prevent someone from sending a message, you might have a First Amendment problem.
Yeah. But there were still, of course, in oral arguments, a couple of interesting points brought up by some of the justices on, these actions. I think it was, Brown Jackson was clearly the most skeptical, I think, of the NRA case, or at least her questions were the most skeptical and probing in that regard. And I think Justice Kagan had a couple of really solid questions as well that were on the skeptical side. The first one is, this NRA case is intertwined with a regulatory action taken by Vullo against what it seems like everyone agrees were illegal provisions of some of these insurance policies, at least under New York law. They don't seem to be illegal everywhere in most places in the United States, but I guess New York law is perhaps a bit different. And so that, the question here is, this Carry Guard insurance program that got them in trouble, got these insurers in trouble, that, perhaps there was, that it was illegal, and therefore the actions were justified on that basis, that they actually had done something wrong, and that using this First Amendment defense, there was some concern that basically any advocacy group that faces some sort of regulatory action or some sort of consequences for things they've done wrong, laws that they've broken, could use the fact that they could use this kind of defense might, just undo regulation of any advocacy group.
Right.
Was kind of one of the points at the extreme end, I guess.
That was one of the points that Justice Jackson tried to probe with some of her questions. I think many of her questions are directed toward getting a handle on some basic First Amendment concepts. But also there was that question. And this isn't a question of whether or not you can use the First Amendment as a get out of jail free card, right? Mm-hmm. I mean, the NRA was not arguing that New York State cannot regulate its insurance programs or impose, say, a sanction for its insurance programs if it crossed the line. And I have no opinion on that. I don't know the first thing about insurance law. So
Sure.
let me be clear about that.
Fair.
But that wasn't their argument, though. Their argument wasn't you shouldn't investigate us or you shouldn't regulate our insurance programs, our affinity programs with other insurance companies. Their argument was you can't use the regulatory authority that you have for an improper purpose to silence our speech, which was what the direct and really express aims of the New York State regulators were. I mean, think of it if the infraction had been someone gets a parking ticket and then you say, well, people who get parking tickets shouldn't be able to go to a political rally. The two are unconnected. And you're not saying that because I'm going to a political rally, you can't give me a parking ticket, right? The argument is you can't leverage that exercise of government power, whether or not it's legitimate, for an improper purpose. And that's what was at issue here.
And I guess the other point on that front that I heard in arguments from, I believe from the ACLU lawyer was that they didn't just punish them for the provisions that they were alleged to have violated in these insurance agreements. They kept them from working with the NRA at all in any potential future. No, that was also noted by.
That's right. There were provisions in consent decrees with some of the insurance companies saying that they couldn't do business with, or they would refuse to do business with the NRA, not just in New York, but anywhere in the country.